A case before the Ontario Court of Appeal could change the way death is defined in Canada. Taquisha McKitty was declared dead by doctors more than a year ago following a drug overdose and was put on life support. But because she still has a pulse, the family argues that according to their religion, she is still alive. Joining me from Fredericton with more is Associate Professor of Law at the University of New Brunswick, Hilary Young. Hilary, thank you so much for being here.
Good morning.
So we know Taquisha's family will argue that their charter rights around religious freedom weren't keeping her alive, even though doctors have said she can't recover. Now, from a legal perspective, what are the main issues in this case, and what will it come down to in court?
So there are really three different issues here. The first is, what does it mean to be dead in law? The second one is she dead, given that definition? And then the third one, I think, is really more important in this particular case, which is, even if she meets the legal definition of death, might there be some sort of exemption or accommodation given the family's religious beliefs, given the charter?
All right, so let's talk about this. What is the definition of death currently in this country?
Death is essentially defined either in terms of cardiovascular death or brain death. So brain death is sufficient for death in Canada and in all the Western jurisdictions I'm aware of. So that's a pretty common and robust way of defining death.
Well, it seems that because we have this either-or system, it opens the system up to cases exactly like this one. Seems like unless we have a single definition, we're constantly going to be at odds with ourselves.
I don't think it's really a problem. Doctors certainly don't have any difficulties. Much of it depends on the way in which you die. I mean, most of us don't end up on ventilators in the way Miss McKitty is, and so you generally are declared dead through cardiovascular means. But sometimes, particularly in the context of organ donation, you may be kept on a ventilator such that your heart's still beating, but nevertheless, if your brain has irreversibly stopped functioning, doctors will declare you dead. So in practice, it doesn't really cause any difficulties, at least for doctors.
Now, there are a variety of outcomes that this case could potentially face, but if the courts side with the family, can you give me a sense of what the implications would be for how death could be determined and treated in this country?
Yeah, I mean, much depends on what exactly the court decides. My guess is that they won't change the basic brain death definition of death. I think if they did that, that would have huge implications for law and medicine. More likely would be that there would be some sort of an exemption or accommodation for people who object on religious grounds to death being determined by brain death. The implications of that, I think, are both positive and negative. I mean, for people who hold these religious beliefs, it would allow that to be respected. On the other side, there's certainly value in certainty around when someone is dead in law, and also for practical reasons to give family closure, etc. There could also be resource implications. So if people can be kept indefinitely in an intensive care unit once they're brain dead, that may have resource implications. And finally, some have suggested there could be implications for organ donation as well.
Well, Hilary, thank you so much for joining us. We appreciate it. We'll be keeping an eye on this case.
You're very welcome.